I'm James Lewis. With me is the UK Minister of Justice, Ken Clarke. Ken, thanks for making the time to talk to us today. Wanted to kick off by referring to your time as former Chancellor, so you'll have strong views on appropriate responses to the financial crisis, not least because as Justice Minister you've had to make some tough decisions, tough choices. When you have to deprive the most vulnerable in society of legal aid, do you feel that the commitment to pay off the deficit in one term is proving unwise and unjust?
I think paying off the deficit as we are is the only sensible way of proceeding. I think the whole Western world's got itself into a terrible mess by thinking there was free money, and recovery and growth is getting very, very difficult to start off because of the huge burden of debt that has to be resolved. The British government behaved like the Greek government. It has a similar deficit to the Greeks. We have a rapidly mounting stock of debt, and the only reason we're keeping our head above water and haven't so far been dragged into the turmoil is because we have a credible plan to reduce public spending. The whole point of reducing public spending on a scale which no democratic governments attempted in modern times in most Western countries, certainly not in Britain, is to do so in such a way that you don't damage the vulnerable. So where I disagree with you strongly is that the fundamental look we're having at our huge and bloated and expensive legal aid system is actually somehow genuinely depriving the vulnerable of access to justice.
Okay, but your own funded body, the Civil Justice Council, is funded by the MOJ, has found that at best these cuts will cause delays and difficulties, and at worst will result in what they call a denial of justice for the most vulnerable in society.
If I manage to get all my changes through the House of Lords, we will still have by far the most expensive system of legal aid in the world. No other Western democracy would make taxpayers' money so widely available for so much litigation and legal advice after I've made the reduction. So just to put these comments into proportion. Well, last time I met the backbench peers in the House of Lords who were about to debate this, I said, what you have marching towards you is an army of lawyers advancing behind a line of women and children, saying, of course they're not concerned about the income of the profession, but their only concern is for these vulnerable clients who will be adversely affected if they're not paid at the rate the rate they currently are. I mean, I'll move to the particular if you like, but this presentation of what we're doing is somehow depriving people of access to justice is, I'm afraid, you make other one I rather strongly reject. Yes, it's some, I don't know.
But do you reject the findings?
It doesn't speak on my behalf. It's there to give me opinions, but I don't have to agree with it. And if it goes into the same campaigning mode as the Law Society, the trade, the professional trade unions, they're perfectly free to do so. But it doesn't mean I have to agree with it. I am a barrister. I am a member of the legal profession. I'm most astounded that all previous attempts by the previous government to control legal aid were so unsuccessful. The last government used to consult about once a year on getting the legal aid bill down and never did anything. We have the worst financial crisis in living memory, and the legal aid bill has ceased to be the fastest rising single item of government expenditure, but it's still enormous compared to what it used to be. And I haven't just cut it. What I've done is asked the fundamental questions of, in a democracy, what legal services should the taxpayer pay for those who can't provide their own legal advice? Where there is a sufficient public interest or a really vital personal interest in the taxpayer funding it, of course the taxpayer must do so. But what we mustn't do is just leave untouched system that's grown astonishingly, for making the poor extremely litigious. Because I am a lawyer, you're a lawyer probably, but lawyers do drum up business when there's a steady flow of income.
Sure, agreed. But senior lawyers and judges are making the point that possibly these cuts aren't probably cost it, because it's going to cause inefficiency in the court system, where you have people acting as litigant in person, for examble. So it's going to cause inefficiency, which will let me deal with that. Because the judges are concerned about litigants in person. So don't just give me a list of arguments. There are thousands of them. The litigants in person. Yes, if people pursue the litigation they do now
and legal aid is not available to them, then they will all appear in person. Now, the purely speculative litigation, actually, there is litigation that would not be brought if it was not for the ready availability of public money. Now, going back to the core ones where people feel so strongly, or they have a real cause, an important issue, they still bring it. Of course, if you were a judge, it is more difficult when you have a litigant in person. It's much more convenient to have a competent lawyer.
It makes the system
but the
more
judges are used to cope with it.
And the costs go up.
But they turn up now. Well, do they? I'm not
this
sure.
Is what we're being told
yes, I do. And judges for whom I have a lot of time. They tell me, and I have judges for whom I have a lot of time, very senior and distinguished judges. I'm convinced it's going to happen on a great scale. It'll slow everything down. So, firstly, I don't think it'll happen on that scale.
Right.
Secondly, they all actually know how you have to handle a case of litigant of person. You have to be particularly careful to make sure they get justice and they're not disadvantaged too severely. Anyway, they are disadvantaged a bit by not having an advocate, so the judge bends over backwards to make sure he understands the case and all the rest of it. The judge has to be firm in stopping the non-legal litigant bringing in all kinds of stuff which is irrelevant, not actually the issue, not admissible, whatever it happens to be, and it's a nuisance.
It is, and it slows everything down, doesn't it?
Takes I've seen some very good litigants in person. We get almost professional litigants in person who are quite outstandingly good. I really do not think it is going to be a problem. It's not going to cause problems which make the great savings in public expenditure not attainable. I don't believe that. That is wholly exaggerating the effect of litigation.
Senior people in the profession who are flagging it as a serious issue.
One of my problems, my present job, is that this hasn't happened to the justice system before. Throughout my political lifetime, no politician that I can remember has ever tried to save a penny on anything labelled law and order. The tabloid newspapers demand bones be thrown to them twice a year with ever more amazing changes to the law, facilitating more crimes, more sentences, more litigation, and most politicians have let that go, which is why if you look at my budget or that of the Home Office, they are amazingly inflated compared with our time. Last time I was doing this kind of thing, 20 years ago, I find the figures incomprehensible. So it's quite a shock. It's quite a shock to the political system. I'm having a lot of controversy because I'm trying to take about 23% out of the total budget of the department.
It's very un-Tory of you, isn't it? And to attack, what's
I'm a One Nation Tory. I'm where the Conservative Party always used to be, and I actually do think, and I'm socially liberal and economically liberal. I believe I believe in market economics, and I believe the government should be responsible in running the public finances. I'm a social liberal, so I believe that there are great values in the justice system. I do believe, instead of just drifting on with lawyers getting used to ever more money every year, and drifting on with the process we've had of populist litigation or activity, we should get back to what democracy needs, a properly funded, working, sound legal system.
Let me get a question in there. You talk about populist litigation. Now, to bring you back to the costing point, what I'm getting is the feedback from people is that what's being targeted is, again, the most vulnerable. We're talking about people who will be taking housing disputes, they'll be taking family cases. And what's going to happen is that if there's this denial of justice that the MOJ-funded body, the Civil Justice Council, is talking about, it's going to put pressure on the NHS, other parts of the system, and that when people's mental and physical health is damaged, costs are going to go up elsewhere. It's coming back to this point again, that simply cutting the legal aid budget is going to push costs elsewhere. It's not properly costed.
Campaigning nonsense. If anybody is running the risk of losing their house and their home, they will get legal aid, as long as they qualify financially in other ways. All cases of domestic violence, abuse of children, we're still giving legal aid. What the family practice, we are making big changes there, because we have these ever-mounting problems, very difficult, emotional, serious problems for people, breakdown of marriages and breakdown of partnerships and problems with children. The ever-burgeoning quantity of adversarial litigation, but pursued by adversarial lawyers is not the best way of resolving those. Family disputes, the welfare of children, there are a whole variety of ways one can go about it. Where we're putting money in is less adversarial and litigious ways of resolving things. Mediation, putting more money into mediation. At the moment, in my personal opinion, but I'm not the only person who holds this, for many people locked in these terrible disputes about their children, the frequent appearances in the family court, the legalistic, adversarial nature of the whole thing makes things worse. You and I must probably know people who get obsessed with the problems of and obsessed with the process in the court, which is determining custody, access to children, or whatever. And there are one way of re-examining the whole thing from first principles in every area of law, but particularly family law, is to go back to first principles. What we're trying to do is resolve disputes. The whole point of having a legal system is to mitigate problems, to help people resolve conflicts, and to do justice if there's a conflict between someone's right and someone's in the wrong. The fact that the family problems just need addressing almost fundamentally, but what we're not doing is taking away legal aid from those people of very limited means in cases where their home is at risk or their child's welfare is seriously threatened by abuse or anything of that kind. We have great arguments about the definition of domestic abuse, but that is people trying to broaden the scope of what we're doing because there's more money in it. What I'm trying to do is, what I'm trying to do is, I think what I'm trying to do is identify the genuinely vulnerable, not the vulnerable legal.
So you're taking this seriously, and you are engaging with it, and you're listening
all the
to
way
research
through.
on this.
I want to identify vulnerable litigants, not vulnerable law practices. That's the line I'm trying to join.
Sure. Okay. Moving on then, still on budgetary constraints though, I mean, you talked about ending the bang-em-up culture, your words. This makes complete sense because we're getting towards 87,000 and more prisoners. It is an extraordinary figure, and the costing I've got is £41,000 per year for each inmate is what it costs the taxpayer. And yet there's been a spike in prison numbers since the riots and due to knife crime edicts and this sort of thing. Doesn't this frustrate you, particularly given that the prison population is reaching the maximum of about 89,000?
Well, I think the prison population has exploded for no very serious reason, and it hasn't actually satisfied anybody very much that we now lock up double the number of people we did when I was last doing this job. Sure. So that's where I start from. I have never claimed that I think any government can control the number of people in prison. It depends on the level of crime, which, despite the assertion of some politicians, is not controlled by politicians. It depends on the decisions of judges. I actually don't think politicians should control what the judges do.
So you were uncomfortable with what happened after the riots? Where there was
No, I agree with what happened to the riots. But although the riots you'd have to tackle, and it's now an industry in researching the riots, because quite rightly people are worried about what the riots revealed. But an event occurs like that. I think the courts responded appropriately, in my opinion. It was right to put the tariffs up a bit.
They came under a lot of political pressure, though, didn't they?
But fortunately, they ignored, I think.
Separation of powers.
Well, I very much hope people, as long as I'm around, I very much hope that people sitting hearing an individual case about the liberty of an individual citizen ignore what you call political pressure, which is usually media hoo-ha. No, not after the riots. I don't think it did. I think, as the Court of Appeal, who probably are as scornful as I am of that kind of pressure, have shown when looking at the sentences, no, I think the riot sentences like they're about right. But it caused what I think is a blip. Yes. It depends on what the courts do. There are all kinds of things we can do to stop the upward pressure. If we can stabilise the prison population, it would be a start. My predecessors were just planning on the basis it was going to rise to 120,000 eventually, which is farcical.
Is that right? I mean, I quoted the 89,000 figure as the maximum capacity.
We're up to that's about a capacity now. I think we're over 88,000 now. We've gone up to an all-time high, but it's only very marginally. It's not been the growth of the population.
Something needs to happen to reduce that.
Yes, and what I'm trying to do, all I can do is reduce the pressures and reduce the population. Other things being equal, that depends on crime. That depends on judicial decisions. The bill I've taken through Parliament, if it's enacted, it's estimated will reduce the population by about 2,600, other things being equal. And putting more effort than that into putting work into prisons, tackling drug abuse, doing some rehabilitative work in the prisons, making them more successful at reforming prisoners, to use the old-fashioned word.
Yes.
That's the downward pressure I want to apply.
And it takes me on to my next question very nicely, which is to emphasise the reducing prison numbers. Reducing prison numbers, it has to be all about stopping reoffending. It's rehabilitation that you're emphasising. What I want to ask you is, do you believe private prisons, Birmingham was the first in April, and we got 9 more tenders out, I believe. Do you think private prisons are really the answer?
I think introducing private management into prisons was one of the best things we did in the Thatcher and Major years. And when I was Home Secretary, it was coincided with the very first one, where we had a private prison, Wolds Prison. And so since that time, the last government had a process with new prisons were provided by the private sector. The public sector remained untouched. And what I'm introducing across the whole department actually, is a much more competitive environment on both quality and price, whereby I think you not only save money, you stimulate innovation. You challenge people, if you pay them by results, to improve their reoffending. And that big tendering process involved, as you say, crossing the Rubicon, because it was the first time a big public sector prison, Birmingham Winson Green, had been transferred to private sector management. But in the same tendering process, the public sector, the government managed prisons, won contracts as well. And given what I recall about the huge resistance to change that there used to be in the prison system, things are much better now. And my personal belief is that facing up to competition, actually trying to outperform other people with fresh ideas about how you manage prisons is as much benefit to the public sector managed ones as it is to the private sector.
Have you looked at the research of what's happened in America with private prisons?
Not recently. There used to be. I think I did 20 years ago when we were introducing them here.
Right. I mean, the point
they're good and bad. I mean, I don't look, with great respect to America, I don't always look to America as my model. I think British politicians, you know, I'm not anti-American, don't get me wrong, not far from it, you know, God's own country, I'm very pro-American. But why British politicians are so obsessed with American think tanks and American examples in every area, I'm never quite sure.
No,
America's criminal justice system and its penal system is, not every part of it is the model I would choose here. You, like us, you've got good and bad in America.
It just happens to be America where we have examples of privately owned prisons where the point is that they are incentivized to keep prison populations high. They're not incentivized to rehabilitate and stop people reoffending. It is in their interest to have high prison populations.
Well, that's a very good warning, and I'm trying to develop the skills here to negotiating the contracts, which of course is important because it's a good department, this, but you know they haven't previously negotiated with large companies contracts of this kind.
Which is a real
the incentives,
given that there are 9 tenders out at the moment,
they're as conscious of it as I am.
Yeah,
because Serco's best, you know. It's a company, I think it's a very good company, but they know how to negotiate a contract. And so we've got to be on the ball as well. Yeah. And what I'm trying to put in is incentives on my pet theme, reoffending. You know, part of the contract's got to be based on actually demonstrating you can reduce the reoffending level for this cohort of prisoners. We build in the possibility of that. We've got the first one at Doncaster. I want to build in incentives to have an atmosphere of work, to actually install some working, training, work experience environment into your prison. We'll pay for that. Success, demonstrable success in reducing drug abuse in the prison, because at the moment our prisons tend to be places where people are introduced to drugs for the first time and actually are able to indulge their addiction if they're there. Although it's rather more expensive than outside, drugs are freely available in our prison. So the contracts have got to incentivise tackling that.
On the work point, again, looking at where we already see private prisons, the companies have a profit motive, yes?
Yeah.
When we have inmates working, they are paid as low as 23 cents for the work that they're doing, and they're doing very menial work, sometimes degrading work. Now, you're going to avoid that in the UK.
I hope to avoid that. I've seen better than that in the States, actually, to be fair. But the worst here and the worst in the States is, as you say, not very impressive, quite demeaning. So we have, but I could take you to the best here, and it's a million miles from that. But one of the things I'm sensitive to is, yes, we mustn't put honest businesses outside prison out of business. We mustn't compete on invalid terms. You can't use prisoners as kind of slave labour and make yourself competitive. You must pay them certainly the legal minimum wage if you can, but certainly a proper rate. To avoid people getting enraged that prisoners appear to be earning perfectly good incomes in prison, we propose to deduct from what they pay amounts which you will pay to victims. And actually, I would like to deduct from what they're paid something towards their dependents, because that, I think, will help keep the family together. Sure. But I think you're right. I think the underlying theme of your question, if I say so, is undoubtedly right. What you do have to be careful about in introducing prison work and prison industry is to develop in a way which is not demeaning and is not exploiting captive labour or anything of that kind.
I think the concern
some critics will always claim that, but we're very conscious of avoiding that as we try to develop. As reputable companies are coming in and producing. I want to get more companies in.
Yeah, I mean, there's two concerns. One is that private companies always have a profit motive.
Well, I rather approve the profit making. It's what makes America and Britain so wealthy. If we didn't run our economy on the basis of profit motive, I'd have to make far more swingeing cuts.
Is it appropriate though for public services? Is the question? Is it appropriate for what should be publicly run services? And in the health service with NHS IT, we've seen that it has been disastrous. And we don't want that.
Absolute nonsense. I've been health secretary for longer than I've been in law. Now, the great breakthrough has been getting rid of what I regard as the post-war English debate. This is really old-fashioned ideological nonsense. Public sector good, private sector bad, private sector good, public sector bad, absolute nonsense.
The NHS IT system has been a disaster.
Oh, the IT system. IT systems of every kind. Public sector IT systems have all been a total disaster, or practically all of them. But the reform, no, but the health service, if the health service hadn't got the private sector commitment to it that it has now, which the last Labour government, I've been very much involved in health reform. I was around the start of health reform I was involved, and actually getting a diversity of providers, getting rid of this theological nonsense that because it was a health service, the buildings had to be owned by the taxpayer, all the employees had to be civil servants, and all had to belong to the right trade unions.
Is it you?
No, the IT system was bad contracting. It was a disaster, total disaster. But the private sector running, I had a relative recently treated in a private sector treatment facility at the idea by a teaching hospital is absolutely magnificent. If we'd listened to sort of Attlee-type ideologues who said, oh, no, these people are running this for a profit, we mustn't let them near here, the health service in my part of the world would be the old-fashioned, bureaucratic, run-down National Health Service, which I remember from 30 years ago. What we're doing now, and the political argument's dead here. People can't say, oh, you shouldn't allow private sector provision of health, because the Blair government actually accelerated the introduction of the private sector providers alongside public sector providers into the delivery of the service, probably rather faster than we did, than we would have dared. And that's sterile and dead, as it is in the prison service, as I think it is in other parts of the criminal justice system. If you're providing a service, at my request, to the public, I couldn't care less whether you're a civil servant or whether you work for Serco. What I want to know is, are we paying you the right price to deliver what is in the public interest? And let us not go back. Let us not go back to the debates of the 1950s. If we ran department stores like that, we'd still have the old-fashioned Sainsbury's with the cheese counter in the corner. And I mean, remember what the co-op was like? Even the co-ops now join capitalism, and it's rather a good sort of retailing store.
Moving on
it was a joke. The Britain of my youth was dominated by the co-op, the trade unions, and a stifling belief that a new dawn was being delivered by putting everybody on the public sector payroll and getting rid of the profit motive. And we had dreadful railways, we had dreadful lorry companies, all owned by the state. And don't start undermining the basis of modern capitalism. It's all in a frightful mess at the moment because we've allowed excess and we've playing with a new toy and we don't understand the rules. But to go back to saying, oh, no, in public service provision you should never allow the profit motive would be to take us back 50 years.
Okay,
I think.
moving on. I want to move on to a little section on sort of rule of law issues and the Justice and Security Green Paper.
Back to my current brief, yes.
Yeah. I just wanted to touch again on sentencing and just the response to the riots, which we referred to,
Sure.
but in passing. I'm just wondering if you are a bit uncomfortable with what looked very like political pressure after the riots on magistrates and cases going to the Crown Courts and it being escalated all the way up to the Appeals Court. It seemed like an unseemly breach of the separation of powers, and it looked like an issue of rule of law to me.
Well, particularly examples of where you think that happened, there wasn't any pressure. I mean, no directions were given to the courts in any way. If any of my colleagues had started seeming to give such directions, I mean, they can call for reactions, but I believe that justice is administered by courts. The one thing we did ask, which was very impressive, was they should. I was a bit worried whether the service could cope with the sudden rush of people. There was, I think, good public interest reasons for having the all-night courts and so on we had, because it did quieten the turmoil that it was dealt with so promptly and swiftly, but it was dealt with justly as well, I think. The reason we were able to cope was everybody, magistrates, court staff, probation service, prison service, defence duty solicitors. They all sensed that this was a serious problem, and they had to show we could deliver swift and sure justice and response. The actual tariffs imposed, the statistics are independent, and there are statistics, but they give an exaggerated extent of the way the sentences went up, because they were. But we charged looting as burglary, but it was no good comparing these looting cases with an ordinary burglary. The sentences were a bit stiffer, I think, towards the top of the range. My personal, there'll be one or two cases. There'll be one or two cases where we raise your eyebrows, and that's what the Court of Appeal is for. That always happens. But by and large, I think it was legitimate for the courts to take into account the background of public disorder when imposing the sentences. The circumstances did, I think, justify taking a pretty severe view. The Court of Appeal has been taking the appeals very seriously, and their opinion is more important than mine. They endorsed it. I don't think that political pressure played any improper point. You can't stop public debate. You can't stop the public reacting in the way across a wide range of members of the public how they do. The tabloid press are always going to say you should be hanging them all from the lampposts and all this kind of thing.
But if they're quoting the Prime Minister, obviously there's political pressure, isn't there?
Yeah, if there was political pressure and it affected the sentences, I rely on the Lord Chief Justice has been sitting personally in the Court of Appeal to sort of just lay down some ground rules. They'd have allowed the appeals if anything like that had happened. I looking at it all, and everybody says now an industry broken out of researching the causes, consequences, and everything else of the riots, which was fine. But I think I was quite proud of the system. Really, I thought we functioned well.
Let me move on then, because we've got a lot to get through in limited time. The Binyam Mohammed case has thrown up some very interesting issues, notably with regard to classified CIA information coming out in the UK court system. And it's led to secret courts settling of cases to avoid that information coming to light. This looks a lot like America interfering with UK sovereignty and undermining rule of law. Rather than settling the cases or conducting secret trials or appointing special advocates, shouldn't justice in the UK be allowed to run its course? Not least because settlements could prove extremely costly.
Well, there's no country in the world which has an intelligence service which functions where you're ever going to have a justice system where the spies all come out, identify themselves, give their evidence in public, all the intelligence material is revealed to the other side, reported in the press, and all the rest of it. You might as well give up.
Of course, that's an extreme characterisation.
You give up an intelligence service. Yeah, that's right. So but all I'm saying is there have got to be constraints. There are a whole most other walks of life. You and I would agree. No, you've got to give your evidence, and it's all got to be disclosed and all the rest of it. So what we've tried to do is get the balance right between seeing justice done on the one hand and not compromising genuine national security interests on the other. And the access to foreign intelligence, which is given to us on a confidential basis, is a relevant factor to that. The Americans and others, but most importantly the Americans, don't share the intelligence material with us on the basis that it's all going to be disclosed in litigation in the British courts. So what we're trying to get is the balance right. We've taken a long time producing this green paper, because I share all your sensitivities about justice and the accountability of intelligence services and so on. What we're proposing is better than we have now, because it will allow the cases to be tried. And when you get into those areas where there are genuine, compelling national interest reasons why you can't handle it as ordinary evidence, either witnesses or material, you go into closed session. The difference from now is the judge with special advocates. No. And the judge, for the first time, will be able to reach a conclusion. Unfortunately, only he will have heard all the evidence.
This is the
client will only get the gist of it. But at the moment, you can't try them. They just collapse at the moment.
But let me just put it to you.
In America, they try them with just leaving the intelligence stuff out.
You know, civil claimants can't be told by the special advocate what's happened in the court.
They can be given the gist of it.
The gist, okay.
Well, yes, but we are consulting. If you can strengthen that. Any decent ideas, we're welcome. I want to make the gisting as strong as we can, but of course you can't. But
if they can't instruct their special advocate, how is this a fair trial?
If he's a villain, the thing he's dying to know is, how did they catch me? I mean, don't just prejudge them, but some of them...
Well, absolutely, let's not.
No, but don't treat them all as also innocent victims either. Some of these people who are bringing actions for damages or whatever, and the Bin Mohammed case, we've got a sort of Norwich Pharmacal application and all that. Some of these will actually be very dangerous terrorists. Now, the one thing he's dying to know, and his lawyers are dying to know,
is that your presupposition?
Is to know how did they get us? Who have we got who's shopping us? What techniques were they using that got us? And if lawyers won't face up to the problem, that he can't be allowed to know that, there's no solution. What I think, put forward in this green paper is a solution which at least will enable the judge to hear everything, and at least to enable the gist, sufficient one hopes to allow him to defend himself, knowing the type of case he's facing, to the plaintiff, if he's bringing a claim, defendant, well, the criminal case is not going to apply, but it's civil actions we're talking about, so that it can be done properly. At the moment, what happens is the minister puts in a public interest immunity certificate claiming national security, and it's never heard. Neither side can use it, no evidence, case collapses, you have to settle it. In the Guantanamo Bay detainees case, everybody's left believing their conspiracy theories. Everybody's on the side of the complainants, believes the British were complicit in torture. Everybody on the other side thinks we're paying out millions of pounds to terrorists because the lawyers are being so silly. As a citizen, I would like the judge to have been able to reach a position where he could declare a decision in that case. And what I'm putting forward is a proposal that would make that far more likely, and we're consulting on it, because I'm worried about how does the special advocate take instructions. He's got to know roughly what he's going to face. How does the special advocate give the gist of the case to the defendant? Is the special advocate in a position really to challenge what's going on and so on? All those are important questions, but they're ones to which we have to find an answer without compromising national security. On that, the final judgment is going to be the judge. I think what is most important is it's no good just me writing a certificate saying national security is settled, because I've been involved in the old days in PII cases where we're covering up the incompetence of the Department of Trade and Industry. We weren't protecting national security. Not me, I hasten to add. I was entirely exonerated.
But that's the worry, isn't
in the
it?
inquiry.
But to cover up all sorts of
the arms to Iraq case was a complete abuse of security things. The protection against that is that in this case, the special advocate will be able to argue this should not be closed proceedings. The judge will be the final arbiter of what is in closed proceedings.
So what's the likely impact of the UK's chairmanship of the Council of Europe? Is the Human Rights Act safe?
Well, the main thing we're going to concentrate on in the Council of Europe is trying to get reform of the Strasbourg Court, which people have been talking about for years and years. We keep getting declarations. I attended a meeting in Izmir where the Turkish presidency were keen on reform of the court. I think there are high hopes on the continent, not just here. The British presidency has the opportunity to get much needed reforms of the Strasbourg European Court of Human Rights, not to undermine it, but to put it into a position where it is better able to give rulings on the sort of cases which require an international court. At the moment it has an arrears of 160,000 cases. They keep piling up. Some of those are trivial. Most of those could easily have been resolved in national courts.
A lot of them are complaints about slow justice in Italy, aren't they?
Well, that kind of thing. Well, that's such a bit of Italian law reform is required if there are a lot of... I didn't know there were a lot of those. Yes. But they're out of scope. They're not the sort of thing the court should really... Sure. And all kinds of things are delayed because you've got stays of judgments whilst they hopelessly wait to get heard in Strasbourg. We hope to tackle that and get some understanding of what you require an international court for, which is obviously to make sure the convention is properly applied. Normally, most of that should be left to national courts, national parliaments. Strasbourg Court is required where there's something new, a major issue of principle, a major failing to apply the convention. Now, it's 47 member states, difficult to get unanimity, but it isn't as the British, it's lots of other democratic states in Europe who wish to see this reform in place. And the whole government, not just my department, I mean the Foreign Office lead in the Council of Europe, but for the Prime Minister downwards, that is our major target in this 6 months.
So how about the Human Rights Act? Is it safe?
Human Rights Act, we've got this commission looking at it. I mean, any change we make, the coalition policy is quite clear, we are going to comply with the European Convention of Human Rights. It's extremely important. The British lawyers were the authors of the European Convention of Human Rights. It hasn't got the relevance to us it used to have in post-fascist Western Europe, but post-Cold War it has a very great importance to us, and I think it's very, very key that we keep these values there across Europe and that we apply them properly in the United Kingdom. The alternative to the Human Rights Act that some people canvass is a Bill of Rights, so this commission is looking at the arguments for a Bill of Rights.
Strasbourg, the Bill of Rights.
Yes, the one thing we're absolutely clear of, government policy, you'll find government backbenchers carrying on about it, but the government policy is most undoubtedly that we are committed upholders of the European Convention of Human Rights. It's important in the modern world, and we do think that the British courts do apply it properly. They use the Human Rights Act.
Okay.
It comes from.
You've expressed your wish to promote legal services as the country's most promising exports. It's currently 2% of GDP, I think is the figure you've quoted. What does the UK offer that Singapore or Stockholm doesn't?
Singapore's a serious rival. Singapore's a good legal centre, and we have to face up to the fact that in the modern global economy, which we trust is going to be restored, high-quality legal services, high-quality resolution of international commercial disputes is a very, very important feature. And as the British are trying to recover economic growth by concentrating on things which are our strength, I think the quality of our law, including our commercial law, quality of our courts, the reputation of our legal and justice system is one of the strengths of this country. And I think I should help the legal profession and the courts market it to the world, because...
Shouldn't justice be above commoditisation and commercialisation?
It's a service. It's a service.
Isn't it about more than that?
It's extremely important. It's a service of fundamental importance to a free society,
right? And
it's also a fundamental importance to a free economy. I mean, when I look at Africa and say, how do you get a market economy that is benefit to the people of Africa? The first requirement is the rule of law. You cannot have a proper functioning market economy without the rule of law. When I look at a foreign country, I judge its access to it by saying, is this a country where the government might lose some litigation in its own courts? And there are very important trading partners where to have such a thought is folly. Now, ours, we have one of the best systems in the world. We have a very high system of standard of commercial law, both our actual legal system itself, our contract law and so on, amongst the most popular in the world, And our courts are ones that people have great confidence in, and they can provide the proper service to people who are engaging in international trade. Perfectly legitimate, I think, to attract people, to get across the idea that British legal services have something to offer to the merchants, as it were, in other countries. It's as long as we're not compromising.
Are you comfortable with the new modernised Rolls building, which is
I haven't
costing the
seen
taxpayer
it. Haven't seen it yet.
where we have two Russian oligarchs having a fantastic service, whilst you're having to cut 350 million.
I met
from the
one of the
legal
advocates in it
budget.
recently.
There seems to be
They're
a
paying for it.
polarity there.
They're paying for it.
They're paying for it.
I mean, everybody has access to the courts if they're resident, and that's right. And what we've never done is filter litigants in the British system on the basis only nice people and only British people and only can have access. So, fortunately, the great thing about any justice system is everybody's got there. And I wouldn't discriminate against Russian oligarchs. They're providing a fascinating dispute, but we're not giving them legal aid, and they are probably, obviously, both of them would appear to have every confidence in the British system of justice to resolve their rather sizable dispute.
Very good note to end on, Ken Clarke. Thank you very much indeed.
Thank you very much.